FTC bans employee non-compete agreements. The Federal Trade Commission, FTC, has voted to approve a proposed rule that would ban employers from using non-compete agreements with nearly all employees. The FTC estimated that 1 in 5 U.S. workers is bound by a non-compete clause. The proposed rule change was open for public comment in early 2023, and more than 26,000 comments were received. Some business interests opposed the rule change. The U.S. Chamber of Commerce wrote the FTC in April 2023 saying, "Such a proposal fails to recognize that non-compete agreements can serve vital pro-competitive business and individual interests, such as protecting investments in research and development, promoting workforce training, and reducing free riding, that cannot be adequately protected through other mechanisms such as trade secret suits or non-disclosure agreements." Unless challenged successfully in the courts, the new rule will take effect 120 days after publication in the Federal Register, scheduled for May 7, that is, September 4th. According to the FTC, the final rule allows existing non-competes with senior executives to remain in force because this subset of workers is less likely to be subject to the kind of acute, ongoing harms currently being suffered by other workers, subject to existing non-competes, and because commenters raised credible concerns about the practical impacts of extinguishing existing non-competes for senior executives. The rule bans non-competes by providing that they're an unfair method of competition and therefore a violation of 15 U.S. Code Section 45. According to The Times, employment lawyers say the use of employment non-competes has exploded and that non-compete and trade secret lawsuits roughly tripled from 2000 to 2017. Assume the new FTC rule goes into force. Employers will need to revise their standard employment agreements that start after the rule's effective date to remove non-compete language. However, employers can still use other legal tools to protect their businesses. For example, a confidentiality clause in an employment agreement or a standalone non-disclosure agreement (NDA) can state that customer lists and customer information, such as buying history, can be protected as an employer's confidential information. Most states also allow employers to include non-solicitation clauses in employment agreements. A non-solicit prohibits an employee from soliciting a company's clients, customers, or employees after that employee has left the company. For example, calling a former employer's clients and asking them to switch their business to a new employer would widely be considered solicitation. A LinkedIn status update merely informing the public about an employee's new job would likely not be considered solicitation. However, a LinkedIn post that actively solicited business for an employee's new employer was held to violate a non-solicit clause in a 2017 Minnesota case. Need help protecting your intellectual property? Book an appointment with us at www.eonlaw.com. Aon Law. Unleashing Genius.